Minister, thank you for joining us on The Big Story. Minister, take us through the thought process of why the government has decided to repeal Section 377A now in 2022 in the context of perhaps the latest judgment.
You heard the Prime Minister last evening. I, the Attorney General, both advised him that there is a significant risk of Section 377A being struck down in a future challenge on the basis that it breaches the equal protection provision in the Constitution. The Attorney General and I came to this view. We talked to other lawyers as well, but we studied the judgment. We carefully studied the judgment, and in this case, the Court of Appeal ruled on many points, but it expressly refrained from ruling on whether Section 377A breaches the equal protection provision in Article 12 of the Constitution. Now, let me explain. There were several challenges to Section 377A based on the Constitution. For example, that it was in breach of Article 9, which protects life and personal liberties. The Court of Appeal dismissed it. It was argued that Section 377A was in breach of Article 14, which protects freedom of speech and expression. The Court of Appeal dismissed that argument. But when it came to the challenge against Section 377A, by reference to Article 12, Article 12 is the Equal Protection Clause. The Court of Appeal expressly said they are not going to rule on whether Section 377A breaches Article 12. And they said that there were two ways in which Article 12 could be applied. Under one of the two ways, if you read the judgment, the Court of Appeal essentially said that Section 377A could be unconstitutional. It could be in breach of Article 12. The court added that they did not have to decide on the right test now. They left it to, I quote, a suitable occasion in the future, which in my view means they can and probably will decide it in future. Subsequently, in other cases, the courts seem to have accepted the test, which, if applied here, could mean that Section 377A is likely to be held unconstitutional. So, in summary, they dismissed the challenges on Articles 9 and 14, but left open the questions on Article 12 and signaled that Section 377A could potentially be unconstitutional. And they said they can deal with it in the future. Now, our courts have over the decades exercised restraint in such questions, as they did in this latest judgment as well. They recognize what is in the sphere of Parliament and what is in the sphere of the courts. You see it in the judgments, you see it in speeches of the judges outside of judgments. If, however, Parliament doesn't act either because of fear or because of a lack of will, and therefore doesn't deal with a law which may be in breach of the Constitution, then the legislature, that's the Parliament, is not doing its job. Then you make it difficult for the courts to exercise restraint. Our system has worked well all these years because all the three branches, Parliament, the executive, that is the cabinet and the civil service, and the judiciary, i.e. the courts, all three work within their respective boundaries, fulfill their respective roles, and work well with mutual respect. If, however, Parliament doesn't deal with a law which is potentially unconstitutional, then you may then leave the courts with no choice. They have to interpret, and if a law is unconstitutional, they may well say so. Now, I know there are lawyers who believe, they've said that to us too, that our courts will not take an activist approach and aren't likely to strike down Section 377A. I prefer not to go into descriptions of our courts as to whether they are activists or non-activists. The point is this: it would be irresponsible for us as a government to assume that the courts won't strike down Section 377A even if they thought it was not constitutional. So looking at the Court of Appeal's comments and the state of the law as it is, we have to make a careful, logical assessment. You can't proceed on these things on the basis of hope and wishful thinking. Hope and wishful thinking cannot replace a careful legal analysis. And our analysis led to the conclusion that there was a significant risk that Section 377A might be ruled unconstitutional in a future case. And mind you, the legal risk is not only to Section 377A. After that, the definition of marriage itself can be challenged. Marriage in Singapore is now defined in the Women's Charter as between a man and a woman. It can be challenged. It can be asked, Article 12, equality provision, why should a marriage only be between a man and a woman? Why shouldn't it be possible for two men or two women to be married? Someone could argue that marriage policies are in breach of Article 12 too, Article 12 of the Constitution. And such arguments about marriage have been made elsewhere successfully. And it will not just be marriage. Many of our laws and policies built on the current definition of marriage, public housing, education, media, what can be shown free to air, many others, all of this could be challenged. So we decided the government must take responsibility and act now. These are issues that should be dealt with in Parliament by MPs, elected representatives, rather than the courts, as the courts themselves recognized. Then the next question is, if you think there is a significant legal risk, what do you do? Government had many different possibilities, choices of action, courses of action. Some have said enshrine Section 377A in the Constitution. Others have suggested other ways, paths of less resistance. And if you enshrine 377A in the Constitution, that will prevent a legal challenge. Or do other things such that 377A, a challenge to 377A will not matter. Government has the majority to do that. But is that the right thing to do? We decided the right thing to do is the course that we have put forward. Government has repeatedly said what consenting adults do in the privacy of their bedroom is generally not a matter for criminal law. So it would not be right to enshrine Section 377A in the Constitution. It will also not be right just to leave it alone. Right thing to do is to decriminalize, stop making it an offense for gay men to have sex. It doesn't mean anyone has to approve it. It just means it is not criminal. People can have their different views on this matter. And the right thing to do also, as I explained earlier, is to protect the family structure.
Minister, the government has said in the past that it would only move on this law when society is ready. And yet, what you just described, it sounds like we are actually doing it now because there's a risk that the law can be struck down by a court in a future challenge. So can you tell us a bit more about why now and not later?
I explained quite a bit on what the right thing to do. The legal position, I have explained the risks. But the more fundamental question was and is, what is the right thing to do? If you have been following the debates on both sides, very passionate viewpoints have been expressed. Now, you will see in this context, the easiest thing for the government to do would have been to just leave it alone, do nothing. And if we did nothing, if we left it to the courts to strike out Section 377A, the government would be able to just shrug its shoulders and say, well, we didn't do it, the courts did it. That way the government avoids carrying the responsibility. It would have been the path of least resistance, easier path. If you approached this issue simply and purely as a politician concerned about votes only, then you would take this course. Try and avoid doing anything, just pretend that it doesn't exist, leave it to the courts. But if you ask yourselves, what is the right thing to do regardless of political cost, then as PM said last night, our laws have to keep pace with social mores, society changes. Gay people, they are our family, our colleagues, our friends. They deserve dignity, respect, acceptance, as the rest of society does. And it would be wrong to continue criminalizing their sexuality, criminalizing what they choose to do in private. Nobody deserves to be stigmatized because of their sexual orientation. So repealing Section 377A, removing their pain, is the right thing to do. And at the same time, in our view, keeping quiet, passive, and letting the courts deal with it carried with it the great risk of damaging the fundamental fabric of society, the structure of family. I explained that earlier. Because it will risk the current definition of marriage. The current definition of marriage, why it should only be between a man and a woman, can be challenged. And our housing, education, social policies, many other policies would be at risk. These are serious issues. So if the courts rule Section 377A to be unconstitutional, it would set a bad precedent of the judiciary intervening in what is really a political issue, which they recognize as a political issue. And the reason they have to intervene is because the executive and the parliament have failed to do our jobs. We failed to do what we need to do. And then everything could go in one sweep. The courts cannot do a balancing exercise. They just apply the law. They say what the law is. Parliament can do a careful balancing exercise on where to take society. That's the role of a responsible parliament. And if a parliament doesn't discharge its duties, then the courts will apply the law because they will be faced with it. A responsible government, therefore, cannot stand by and be passive and let this happen if we believe in Singapore and we believe what makes Singapore successful. If we believe that the family is important, and we do, then we must move to prevent legal challenges to the current family structure. Some of the people who oppose the repeal of Section 377A don't, I think, appreciate this risk to the family. They don't realize that the government has actually thought this through several steps and is moving strongly to protect the family structure in Singapore. So I'll summarize two things. Right thing to do is, one, decriminalize gay sex amongst men, and at the same time, two, protect the family, protect the current definition, the marriage is between a man and a woman, protect our education, housing, and social policies.
Minister, let's talk about political cost. You stress it's the right thing to do. It's a contentious issue, 377A. You said, the government could have just let the court deal with it, but you didn't. So what is the political cost? What is the political hit there?
You see the tremendous amount of passion on both sides that this discussion has unleashed over the last several months. You see all the statements issued by religious groups as well as non-religious groups, LGBT groups. Big arguments. We want to keep the social fabric intact. We want to keep social harmony. We want to achieve the right balance. Now, however, if we just kept quiet, put on, as I said, put on the helmet, go into the bunker and pretend that nothing is happening, leave it to the courts. And if the courts did strike out Section 377A, we can come out and say, well, the courts did it, not us. By taking these steps, these are not vote-winning steps. This is going to carry, it's going to make people unhappy when they believe that a different course of action is the right course of action. What we have to do is to go and explain to them why we are doing it, why this is in the interest of Singapore, and how we are balancing all the different interests, and how the family structure will actually be better protected hereafter. But these are not easy things to do. It would have been easier to have kept quiet.
Minister, you spoke about protecting marriage, and last night PM Lee said the Constitution will be amended to ward off legal challenges against the definition of marriage. So can you tell us a bit more about how this will be done?
I want to be clear because I think there is some confusion. The definition of marriage is not going to be in the Constitution. That's not the intention. The risk is that the current definition of marriage in the Women's Charter can be challenged on the basis that it's in breach of Article 12 of the Constitution. So what we are planning to do is to put it in the Constitution explicitly that Parliament can define the institution of marriage, and in the way it has defined in the Women's Charter, and it can make other pro-family policies on the basis of that definition, or that marriage is between a man and a woman, and that these laws and policies which rely on the definition of marriage cannot be challenged in court by reference to Article 12, or by reference to the Constitution. So this means the definition of marriage in the Women's Charter, it will make it difficult to challenge that definition on the basis that it's unconstitutional. It will have to be dealt with in Parliament. So if a party, group of people want to allow same-sex marriage, they will have to put that in their manifesto, fight elections, win the elections, get a majority, and then change the definition of marriage. This government's position is very clear, and you have also heard what DPM Lawrence has said. We are committed to strengthening the current structure of marriage, strengthening the family structure, and the policies that surround that structure of family. We think that's what's is fundamental for Singapore, and in fact we are amending the Constitution to strengthen that position.
Minister, you've been on the forefront of this contentious issue, and you've spoken at great lengths. To put it simply, you're like the face of it. So following the announcement that 377A will be repealed, what are the concerns and responses that you've received so far?
I'm not sure I'm the face of it. As I said, I advised Cabinet and Prime Minister together with the Attorney General. But yes, I have spoken about it to many groups, but so have other ministers. We have all gone out there, gotten feedback, explained our thinking, explained our position, and there is a lot more of this that needs to be done. And we need to take the concerns seriously. And I take the concerns very seriously. And I can understand the concerns that have been expressed by, for example, religious groups, as well as non-religious groups, others, people on the street, as it were, who don't have a particular religious viewpoint, but they don't want the tone and fabric of society to change overnight. So let's look at these concerns. I'll refer to a 2018 statement by the Presbyterian churches in Singapore. That statement, for example, says, I'm summarizing, I can't quote, 377A, should not be repealed as a moral marker of until and unless for certain rights and guarantees are included in the Constitution. If you look at what they want, say religious freedom and rights, that there would be no legalization of same-sex unions, adoptions by same-sex couples, and similar policies. 3, that the laws will not penalize and discriminate against those who do not support the homosexual lifestyle. If you look at a statement that was released last night by the National Council of Churches in Singapore after PM's NDR speech, they said, look, again I'm paraphrasing, they are worried that there would be more contention and advocacy for civil unions regardless of sexual orientation. They want our social policies on housing, education, adoption, advertising, film classification. They don't want any change on that. 3, the religious freedom for churches to teach or counsel should be protected. And 4, that people should be protected from reverse discrimination in workplaces if they do not support LGBTQ plus activism or culture in workplaces. So if you go back to the 2018 statement by the Presbyterian churches, what are they asking? They are asking for safeguards to be in place before Section 377A is to be repealed. If you look at both statements as well as the petitions and other statements that have been issued, I think I can summarize the concerns in 4 main areas. First, the concern is whether there will be a shift in our laws on marriage and the laws on policies that are centered on marriage like family formation, education, and so on. 2, freedom of religion. Now, 3, pressure. They are worried that there will be pressure to accept and conform to LGBTQ plus ideology in schools and workplaces. And 4th, they are worried about cancel culture, that they will not have the freedom to express their views on sex, gender, marriage, and family without being silenced. Let me deal with all 4 points. I think it's important to deal with these points and be very clear where the government stands. So on the first point, our policies on marriage, other related policies centered on marriage, I've said housing, education, social policies, they are not going to change. In fact, we are going further. We are going to protect these policies from a legal challenge by amending the Constitution. On the second issue, freedom of religion, the Constitution guarantees full protection for freedom of religion. That's absolutely safeguarded, and it's a cornerstone of article of faith for us. People must be free to practice the religion, and people must be free to be, non-religious, not believe in a religion if they don't want to believe in a religion, or agnostic. It's a free country. They should be able to do what they want in that context. Then, if you look at the Maintenance of Religious Harmony Act, I call it MRHA. I amended it in Parliament, took it through Parliament last year. It sets out clearly that people should not be targeted on the basis of religion. It of course applies both ways. If a religious group or member is attacked by a non-religious group, such as an LGBT group, action can be taken and will be taken. Likewise, action can be taken under the MRHA if a religious group using religion attacks a non-religious group such as LGBT groups. So both sides should have freedom to share their views. They can express their disagreements with each other as long as it doesn't cross the red lines in the law. I made this clear in Parliament when MRHA was debated. So the third issue, pressure in workplaces and schools. Workplaces should be part of the secular space shared by all Singaporeans. They should not be places where people are compelled or pressured to participate in or support non-business related causes. Employees should not be discriminated against at work just because they hold traditional family values or pro-LGBT values. So MOM, Ministry of Manpower, is looking at this issue, including protecting employees from being penalized or discriminated against, in many respects. It is also looking at processes to protect those who report about workplace discrimination or harassment so that people can feel safe about coming forward. People tell us employees feel compelled, particularly at foreign MNCs, to put up the pride flag, for example. These are matters of conscience. There should be no compulsion or pressure, direct or indirect. MOM is looking at these issues. It may be that we have to advise employers, particularly foreign employers, to be more careful and sensitive in Singapore. Now, don't get me wrong, they are looking at this. It doesn't mean that all of these things can be in the law, for example, non-discrimination. But I think they are looking at all of it. Certainly, I think, we don't want pressure or compulsion, both on the side of LGBTQ as well as on the side of religion. People should be free in their conscience. This is a country where many people are religious, and that should be respected. On education, you've seen the statement that MOE has issued. I think essentially they say that schools should be safe spaces for all students. So education policies, including sexuality education curriculum, will remain unchanged. Sexuality education will remain secular, based on traditional values, and sensitive to the multiracial, multi-religious makeup of our society. And they have said they will not tolerate bullying and cancel culture, and that the schools will partner parents to guide children towards understanding, respect, and empathy. So, students should not be bullied because they have LGBTQ tendencies. They should not be bullied or ostracized if they do not hold pro-LGBTQ views or they hold religious views. The fourth issue, cancel culture. In the feedback we have received, many are worried about being cancelled, and I take that very seriously. My ministry, the Ministry of Law, has been looking at measures to deal with the harm caused by cancel campaigns. People ought to be free to express their views without fearing being attacked on both sides. So we plan to do something about this. The religious groups feel their freedom to express their views, to preach, is being curtailed by groups which cancel them, harass them, attack them. We cannot sit by and do nothing. People must have their freedom to practice their religion. Preachers must be able to preach. And likewise, as I said, if you don't hold pro-religious views, if you hold views which are opposed to religion, you are free to, and you must be free to hold your views. So we intend to do something about this. And we have to look at the right boundaries between hate speech and free speech in this context. And we should not allow a culture where people of religion are ostracized, attacked for espousing their views or their disagreements with LGBT viewpoints, and vice versa, whether pro or anti-LGBT.
If you could, Minister, shed some light on the timeline, how soon will we see the repeal of 377A take effect?
We have been talking about this for some time, spoke about it in Parliament several months ago. There's been a lot of discussions outside with people. Viewpoints have been taken, feedback has been taken, ministries, different ministries have been working, which is why you see, the Ministry of Education putting out a statement. All the ministries are quite clear where the lines are as a result of the changes announced by the Prime Minister last night. Government's views have crystallized after this period of intense feedback and discussions, and now we will have to move. And the changes itself, in terms of legal drafting and so on, will not take much time. It's a question of how long internal discussions take, and I am not in a position to give you an answer on that right now. But I don't expect that it will be very long.
And Minister, what's your personal take on the resolution of this messy compromise? What does it mean for you as a minister and a Singaporean?
In these things there is collective responsibility. So Cabinet members do not express their individual viewpoints. We take a position, we debate, we deal with it internally. But as I explained, you have to make a careful, logical assessment of the legal position, and you have to ask yourself what's the right thing to do, and then do it. I have explained that taking these steps are not easy. It would have been far easier to have just kept quiet, leave it to others, leave it to the courts and so on, let everything take its own course. But that's not what made Singapore successful. What made Singapore successful, and what I think will continue to make Singapore successful, is a government that is looking at these issues, looking forward 5 years, 10 years, 15 years. What should our policies be? How should we structure our laws? What are the risks of challenge? What should be protected? So we say family is important. We have to protect it, and therefore we protect it. We say 377A, it's unlikely to survive a challenge, or there's a risk, significant risk, that it won't survive a challenge. And Parliament should do its duty by removing it. And it's also the right thing to do, so you don't just leave it alone and leave it for the courts. So, there are many aspects that go in, and I think the messy compromise, society has changed. I think the status quo is not tenable.
Minister, thank you so much for your time and perspectives today.
Thank you.